Today's episode is brought to you by Forvis Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. With changes to Fair Work laws that now make wage theft a crime, Fair Work Ombudsman Anna Booth is keen to ensure that small business owners understand that her office exists not only to crack down on nefarious actors, but to help well-intentioned business owners as well. And there are plenty of specially designed tools to make sure small businesses are complying with the law. Anna describes the role of the Ombudsman to Jeff Waters.
The Fair Work Ombudsman is Australia's national workplace regulator, but we have equal concern for employers and employees. We have a particular statutory purpose. People probably don't want to know the section of the Act, but it's Section 682 of the Fair Work Act, and it's the Fair Work Act that we regulate the implementation of, and only the Fair Work Act.
Everybody's rushing to Google now.
I'm sure. But it's worthwhile saying what it is because it actually sets us up for how we engage with the workplace community, and that is that our purpose is to promote harmonious, cooperative, productive and compliant workplaces. I think if you give me time to be a bit more philosophical later on, you'll see that those conditions are quite codependent. But the Fair Work Ombudsman regulates the entire 1 million employing businesses in Australia. You will often see a number of businesses being counted as higher than that, but we've distilled it to the employing businesses and 14.5 million workers within those businesses. And 94% of those are small business, that is in our world, less than 15 employees. You'll also see a different figure for different measures. But one of the priority areas for the Fair Work Ombudsman is small business. And why is that? That's because, obviously, it's the majority of Australian employing businesses, but it's also because we have a brief to give information, to advise and to educate. And why is that? It's because our key ambition is for all businesses to be compliant. And we think about our world or our work in a pyramid called the compliance pyramid or the regulatory triangle, depending on whether you're working in 2D or 3D. And at the base of that triangle is where we want the majority. In fact, we want all, but we're realistic. We want the majority of workplaces to be in what we call the voluntary compliance wedge. And how do you become and remain voluntarily compliant with Fair Work Act and all of its instruments, which include not just the statutory obligations, but the awards and the enterprise agreements that arise from it? Well, you do that by knowing what your obligations are and what your employees' rights and entitlements are. And you can't expect any small business owner with the amazing array of focus that they must have on their business as well as all the other regulatory arrangements that are required of them. You can't expect them just to know these things. You know, industrial relations is not their core business. So that's why we have a small business showcase amongst other resources that provide them with that information. And perhaps we'll talk a little bit more, Jeff, when you ask me some more questions about those resources. But that's sort of in a nutshell the purpose of the Fair Work Ombudsman and what our core focus is, particularly for small business, is making sure that the business knows what their obligations are and can implement them.
We will get back to those specifics, but before we get there, I'd just like to paint a picture for the listener of the size and scope of what you do. You've said that obviously there are very many millions of workers involved. 95% of your trade is small business. How large is your office and what are you kind of tied up with on a day-to-day basis?
Yeah, we have 1,000 employees. I'm the lucky CEO of all of those people, and they are all incredibly dedicated. They range from people who are at, if you like, our front door, where they're taking phone calls on a daily basis. We get over 300,000 of those a year. They might also be designing our website, and we get around 40 to 50,000 visits per year. And then we have people who are involved in dispute assistance. So if the information we give you doesn't resolve the problem, mainly, of course, in that context, I am talking about employees, then we have a dispute assistance group, but they are equally concerned with the employer and the employee because they will contact the employer to have a chat, and 90% of the occasions that they do that resolve the matter. And then we have people who support our inspection or investigation stage, which would be a stage that is enlivened if it's a particularly complicated matter and it's not resolved through the dispute assistance, or we don't ask the employee to go elsewhere, which we might do if it's not in our jurisdiction, or if we think it's more appropriate that they handle it themselves, we'll give them support to do that. Also coming in, just circling back to the front door again for a moment, will be a lot of employers coming in on our small business helpline, and also for even more intensive support, our employer advisory service, which is designed specifically for small business, and where small businesses can get a written piece of advice which will be relevant to the particular question that they ask. And then we have a whole bunch of, I shouldn't say a whole bunch, they're lovely but highly capable people called investigators who will visit workplaces of our own accord because we find out about things other than necessarily through calls that come into us. But we also will visit workplaces when an issue is such that it needs further investigation and the visit is warranted. And then we also have, I'll say it again, a whole bunch, a lovely bunch of lawyers, and they are both giving advice to our front line again. So all of our advice that comes from our info line and our website is all up to date, like literally the minute, because it's not a matter of setting and forgetting our advice. It has to change on a daily basis. So we've got advisory lawyers, and then we've also got litigating lawyers.
As we generally hear about your office in the media, and it's generally the reporting of a prosecution, I can hear the audience sighing with relief when they hear that you're not necessarily after a prosecution in the first instance, and that 90% of problems are resolved with a simple phone call. Can you expand on that?
Yeah, I can, Jeff, and I'll sort of do it, if you like, from the extreme case back to the more general. Another statistic I think that could give people comfort is that only 1% of all the recoveries of money that we achieve for underpaid workers comes through litigation. And our litigation numbers are around 60 to 70 per annum, only 60 to 70, and that would be particular cases with particular employers. And you generally hear about those cases because they are sometimes quite egregious, and they are at the extreme end where it's quite clear that what occurred was intended. So things like asking employees to pay back in cash part of what is being paid to them in wages so that it's off the books, if you like, or literally employing people for $15 an hour. Or recently I've been reading a few cases where people were employed for a certain period of time, and for, maybe several weeks of a several-week engagement, they simply didn't get paid at all. Those things can't be mistakes.
So if I'm a small business owner listening to this, I am afraid that I may not be compliant. I'm not quite sure. I want to be compliant. I want to avoid any form of sanction or litigation. Where should I go? What should I do? How do I reach you?
I think the first thing to do is to establish for themselves, even in the privacy of their own living room or kitchen where they've got their laptop, through using our online resources. So, for example, we have a small business showcase, which has a whole range of tools on it. We have pay slip templates. We have a paying conditions tool. Small business can use that to calculate award-based pay rates, allowances, penalty rates. We've also got online training about record keeping and pay slips. We've got a self-audit tool that can allow the employer to do all that by themselves. So they can have the confidence that they're doing that by themselves. The second thing they can do is ring 131394, which is our helpline number. I should have said our website address is fairwork.gov.au. If they choose to ring us, then they can be diverted by pressing number 3 to a small business helpline. The advantage of doing that is that they will get an info line advisor who's very familiar with small business business, and they will also get through quicker because the call wait times are shorter for the small business helpline. If they have a particular difficult question that they really want answered with more legal input, and I do stress that we don't give legal advice as such, but we do give advice, then they can ask our employer advisory service to contact them, which we will do, and then we will listen to their whole question and the context of it and write the answer for them. Now, all along, they might be thinking in the back of their minds, I'm speaking to the Fair Work Ombudsman now. They know who I am. They've got my ABN. They've got their number. I can absolutely assure the audience that we do not then move immediately from, oh, you've rung the employer advisory service and it's clear from our conversation that you're in breach. We're referring you on to our investigation team. We do not do that. We are really there to give that advice and to help them remedy the situation. If they do discover, a reasonably significant breach of the law, then they can also self-declare that to us, and our commitment is to begin with an informal but curious conversation. And our goal is to bring them back to compliance. It is not in our interests, and maybe this will be of comfort to the audience as well, because as Paul Keating said, if there's a horse in the race called self-interest, you should back it because at least you know it will be trying.
Yes.
And when people know that it's not in our interests to pursue them to what we call a coercive enforcement outcome or to litigation, because very expensive to do that and involves a lot of people, we have common interest in resolving things amicably. The real state of mind here, that is important, and this is something that only the employer can form, this state of mind. It's good intentions. If you have got good intentions and you are willing to learn and you are willing to engage with us in a conversation, then the engagement with us should be a pleasant one, an educative one, and one that sets you on the right track. Interestingly, a very large number of employers who ask for written advice from our employer advisory service will provide that advice to their employees, which of course they're permitted to do. And that will often increase the confidence in the workplace on the part of the employee that everything's all right. And of course, fundamentally, what we're all after here is workplaces that are great places to work and produce terrific value for their customer in their marketplace so that they're successful and sustainable. And if we can do that, then we know, that we are making a real contribution to our economy and our society.
That was Anna Booth, Australia's Fair Work Ombudsman. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow @BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Forvis Mazars. To find out more, visit forvismazars.com/au. That's FORVISMAZARS.com/au.